of witnesses as well. It's a validation of debts. It's I believe it's a validation of debt that yeah,
Is it
right
you
here.
can't tell a consumer they owe a debt?
No, it's right here. So Perry or anybody, if you make a mistake, you know, what this means in detail is, the failure for a consumer to dispute a liability shouldn't be used to construe him in a court of law because he's not a professional at this, right? So even admission of liability, the failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as an admission of liability. So if you don't cite this section of law that might help you under section 809 or any other derivative there too, it can't technically be used against you. So what I'm saying is if you haven't used this prior in any cases, right now this could be a section that you cite and use that admission of liability. I allege I have no liability in this matter. They treat me like I'm worthless. I allege they don't have possession to the standing and interest to the note, and I allege they've trumped up these charges against me. I've paid them extortion fees if I look at it that way, and I cite it and allege it that way, that it's extortion. I got evidence of paying them. They haven't kept the books accordingly. It's caused an adverse action. So I allege I don't have any admission of liability. And if I didn't cite this before, the failure of a consumer to dispute the validity of a debt under the section of law under the FDCPA or any derivative thereto may not be construed by the courts or any derivative thereto, because the court is the paperwork I allege that they're reading as an admission of liability by the consumer. I'm not liable. I'm not admitting it. Nunc pro tunc. And to explain this in detail, I've committed to the court statements and affidavits provided that are related to the Fair Debt Collection Practices Act, whether it's local or federal law in the United States that regulates the practice of debt collectors. And the FDCPA, often found under Section 809 of the Act, emphasizes that if the consumer does not dispute the validity of a debt when contracted by a debt or when contacted by a debt collector, this decision to remain silent or dispute the debt should not be interpreted by any court as admission of liability. I may have been silent before, but now I'm vocal, now I'm writing, now I'm citing, and now I'm invoking the fact that I challenge the jurisdiction of the subject and the person that claims I owe a debt in any form, fashion, or matter or species, and I challenge the mere standing to the possession of the note and the security instrument that caused the debt, regardless of the case. If I have to file an appeal or take it all the way to the Supreme Court, I may have to. And this is my explanation of a consumer that when I'm allegedly owing a debt and a debt collector attempts to collect it, me as the consumer has the rights under the FDCPA and other local laws to dispute the validity of the debt and the verification thereto by the individual, the collective bodies that say I owe an expense or a deficit on an internal revenue form, single entry or double entry. Without that, there wouldn't be an actual injured party, and that would be a miscalculation and a misuse of a public charge. And this means that any adjudicator in the matter in concert or collection thereto could be charged with obstruction of justice, I allege, if we did a real full accounting. This means the consumer can challenge whether they owe the debt, the amount of debt, or the legitimacy of the debt collection claims. I allege nunc pro tunc now for then. However, me as the consumer, if I choose not to exercise this right, it does not dispute the debt and I do not dispute the debt when initially contacted by the debt collector. I allege I'm not wrong, and even the FDCPA protects me as the consumer from having this ability to remain silent and then to interact it later on when I wish to, when I know. I didn't know before. I didn't have the strength. I was under fear. Now I do know. I affirm this. I cite this on an affidavit. They've been negligent. They've had wrongful acts. There's been red flags. There's been multiple adverse actions, and I declare this on and for the record as the mitigating source, as the power of attorney of fact for my individual rights, living, not deceased, not civilly mortuus, to any secondary credit agency, to any first party creditor. I allege I don't owe the validity of the debt, and without verification under penalty of perjury from an individual party or a collective body of individuals with the delegation of authority to view and state for the record that I owe a debt under internal revenue forms, either 1120 for a corporation, 990 for a nonprofit or a government, any derivative thereto, a 1040 for an individual or sole proprietorship or organization, a 1041 for a trust or estate, and a 1065 for a partnership, and a 4797 not limited to. If I cause loss or deficit, it would be written. If it's not written, if it's not laid out, I allege it's false. It'd be similar to a False Claims Act. It'd be similar to violating securities of the United States. And I allege without a claim for which relief can be granted, there's no claim for which relief can be granted to this court. Nunc pro tunc. And somehow, some way, sometimes you guys are gonna have to be able to put that in writing. Key points: not disputing the debt doesn't automatically mean the consumer acknowledges the validity or accepts liability there too. I just tried to read. I did that on myself to just, I can just go off if you listen back to what I said, I did not make that up. If you go back, everything I said, it's a fact. And I would put that down as a fact. That's my explanatory. What's yours? And you know what? I'm sharing mine with yours. I'm a minister of peace. Use it. Right now, key points. The debtors are required to provide certain information about the debt when they first contact the consumer, or the debt collectors are, such as the amount owed and the name of the creditor. The consumer has a time period, typically 30 days from the initial communication to dispute in writing if they believe there are valid reasons to do so. I allege there could be a billing error. Merge the single and the double entry books together. IRS publication 583 shows businesses can keep funds in an escrow account, keep funds in savings accounts. And I also allege that if I cause the company an expense, loss, or casualty, it would be listed out by a day, week, month, or year fiscally each year. And that's a requirement under the IRC. And I allege if they didn't put it down, it didn't happen. It's hearsay. And I allege the attorney may be on a journey attempting to collect a debt. And I challenge all validity there too. If the consumer disputes the debt within this time frame, the debt collector must provide verification of the debt, and the collection activities must generally cease until verification is provided. And you need to let them know that. And maybe tonight these things will stick in your head, and we can, even me, when I do my homework, I'm going to make the best credit letters for you based on this information. That's what it's all about, is credit. It really is. Or even in